Hello everybody, my name is Natalia and I am a real estate attorney here in the state of Florida, and today I wanted to talk to you about the top 8. Now, what am I talking about top 8? I mean, does your wholesaling contract have these key terms? And I call them the top 8 because if you're missing them, then your wholesaling contract is, well, quite frankly, garbage. Before I move on to the top 8, I do want to let you know that we are constantly making videos that are meant to help out your real estate investments here in the state of Florida. And so remember to subscribe to our channel. And let's move on. Okay, so top 8. Number 1, does your wholesaling contract have a legal description? And why do I say legal description? Because addresses don't necessarily cover the exact same parcel of land that might actually be under your main contract with your seller. So you need to make sure that there's a legal description there that matches what you actually signed with your original seller. Number 2, value, price of the assignment. Do you have a specified amount there that is what you are supposed to be making by assigning this contract to an end buyer? You'd be surprised by how many people fail to have that term there, and if you don't have it, you're creating ambiguity, which is ripe for litigation. All right, so number 3, this assignment price, is it refundable? Is it non-refundable? You should think about having refundability clauses in your contract. Mainly to protect yourself, it should be non-refundable after a certain period of time. You did your job finding that ideal type of property for your end buyer, and so your job, in essence, has been fulfilled by the time that you assign the contract. So making these non-refundable is something that you may want to think about having in your contracts. Number 4, occupancy. So this is very important. Are you promising anything regarding occupancy in these assignments? Are you telling your end buyer that this is going to be vacant? Are you creating potential liability issues for yourself by making those types of promises? Think about those terms in your contract. Number 5, does your contract explain the limits of Chapter 475 of the Florida statutes? That is to say, does your contract make your end buyer acknowledge that they're not supposed to be marketing this property to anybody else, that they don't have that kind of right unless they have a signed, executed brokerage agreement with the seller? It's good to put that in there because it's kind of your way of saying, hey, I let you know this is not an option. Number 6, do you have an indemnification clause? That is to say, if your end buyer does not perform on that assigned contract, do you have anything in there that will protect you, that will make sure that they have the obligation to pay you back for any attorney's fees, cost of closing associated with not having performed on the contract? So yeah, definitely make sure your contract has an indemnification clause, because if it's lacking that clause, it's garbage. Number 7, is there a jury waiver clause? This is huge. Do you understand how expensive juries can be in making a decision when there's even a brief small dispute in a contract? Your contract should have a jury waiver clause. It would save you so much more in time and money if you have to litigate this dispute. Number 8, is there a term for, like, a space for additional terms? Something where there's line items there, providing you and your end buyer the opportunity to have an additional kind of an agreement built in. Is there an additional time period for inspections? Is there a lease that's being assigned? All these things should be written into the additional terms clauses. So please make sure that your contracts have at least these top 8. For more videos like this, remember to subscribe to our channel. And like I said, my name is Natalia. I am a real estate attorney here in the state of Florida, and I wanted to say good luck out there, investors.